everyone, it's Layla Shaver. We're going to go ahead and get started. So this week we're talking about solicitor's agreements. It comes up frequently, especially towards the end of the year when we get started talking about annual amendments and changes in your business and different disclosures you're going to need to make or update in your Form ADV. And whether to pay solicitors always is an issue that comes up. So this week's presentation is especially timely in light of annual amendment season coming up the next few weeks. So let's go ahead and get started. If I can get my computer to work. So when we're talking about cash fees for solicitations, we're looking to Rule 2064-3. And this rule under the Advisors Act generally prohibits an SEC-registered investment advisor from paying a cash fee directly or indirectly to a third party, also known as a solicitor, or referring clients to the advisor unless the arrangement complies with a number of conditions. Among other things, the rule requires that there is a written agreement between the advisor and the solicitor, a copy of which the advisor has to retain as part of the books and records requirement, and that agreement has to detail the referral arrangement. Second of all, in order to properly have a solicitor, at the time of any solicitation, the solicitor has to provide the prospective client with a copy of the advisor's brochure and then a separate written disclosure document that discloses the solicitor is being compensated for referring or recommending the advisor, and then the terms of that compensation. And that would include any additional amounts the client will be charged by the advisor as a result of the referral arrangement. And finally, the advisor receives from the client prior to or at the time of entering into any written advisory agreement with the client a signed and dated acknowledgement that the client received the investment advisor's brochure and the solicitor's written disclosure document. So those are the requirements of the rule. Now, things can change depending on whether you are a state or SEC registered firms. Solicitors generally will not be required to register separately as advisors with the Commission if they comply with the conditions of the rule. Failure to comply with these conditions, however, could result in liability to the advisor under the Advisor Act's anti-fraud provisions and could result in the solicitor being deemed an unregistered investment advisor. Dave, you had a question. Dave?
Can you hear my voice?
Dave, are you? There we go.
There we go. Okay. So on the previous page, it was talking about the acknowledgement signed and dated by the client. Do you see in most cases that that's just placed on an IMA as another thing for the client to sign and acknowledge as part of the regular IMA in the case where somebody's working regularly with a solicitor?
Yes, it can be part of the IMA because, again, it's before or at the time of them becoming a client, you want that acknowledgement. So it certainly could be, say you have your normal IMA and it's a additional like exhibit to the document where if you have a solicitor that you routinely use, but maybe doesn't bring in every single client relationship,
Right.
then certainly you could have that, or you could build it into your IMA as well.
Like you have two versions of your IMA, a solicitor version and a non-solicitor version or something like that.
Yeah, certainly. The important part being that you get that acknowledgement, and then you want to illustrate that the timeliness of that acknowledgement and receipt of all those documents.
Right.
You don't want there to be any proof that this happened after the fact, after they became a client.
Right. And this was something that at first was going to become really relevant to our firm when we did our initial acquisition, because they were going to function as a solicitor, and then we ended up just bringing them on as IARs with the firm and handling it that way, and so we ended up not going this route. So, okay, that's it. That's all I had.
Okay, and we're gonna actually the next thing we're talking about is the state requirements and kind of being mindful of state requirements, because even as an SEC registered firm, you may be required to have your solicitors be registered on the state level. So it's really important, regardless of whether you're state or SEC registered, that you're looking at where your solicitor is functioning in what state, and making sure you are looking at that state's laws. So most states require IARs to register as an investment advisor representative, because they see soliciting as an act that would fall under the definition of an investment advisor representative. There are, however, other states that don't require licensing or registration. For states that do require IARs to be registered in order to take part in solicitation activities, they're going to have to, qualify for the Series 65 or the combination of the Series 66 and Series 7. Individuals holding certain professional certifications, such as the CFP or CFA, may not be required to pass an examination. So pretty standard exemptions for IARs. So a state that requires solicitors to be registered, you'll still have those specified designations that'll be exempted from the exam requirements. Other states, if you don't necessarily have a CFP, CFA, or other designation that's exempted from the exam rule, some states don't even require solicitors to pass an examination if they are merely soliciting and are not giving investment advice. So again, to figure that out, you want to look at the state's definition of an investment advisor representative and look at what activities or what exemptions are encompassed by that definition. States like Massachusetts and Pennsylvania permit CPAs to be solicitors without passing an examination. They also permit attorneys to be solicitors without registering. However, you want to also consider that, CPAs, CFAs, attorneys, they're subject to certain ethics rules and part of different professional groups or associations. So while the law of a particular state like Massachusetts or Pennsylvania will allow these designation holders to engage in solicitation activities without being registered or without passing an examination, you then also have to consider what a bar association, for example, says about what the lawyer is allowed to do generally. So, for example, here in the state of Georgia, as an attorney, I'm not allowed to engage in referral setups unless it meets a very narrowly defined scope of referral activities through very narrowly defined group of referral networks. So again, while the security side may allow it, you have to look at these different professional groups and associations to make sure that the ethics rules that these designation holders are subject to will allow them to engage in these referral arrangements. So some states do not permit entities to be paid directly, so the solicitor agreement must be paid to the individual. So this is something to consider where the solicitor is not necessarily the owner of the RAA and the owner wants to somehow receive a part of that solicitation fee. So again, making sure you're looking to state law to be very clear on what kind of arrangements are allowed. And then, of course, there are states that distinguish between SEC and state registered advisors. So in Pennsylvania, for example, solicitors who refer prospective clients to SEC firms are not required to be registered, but if they are referring prospective clients to state registered firms, they are required to be solicitors. So state laws vary, and you want to make sure that you are looking at the state law to understand really the whole scheme behind solicitors and what would be required, what's not required, what are the exemptions. So it's really important to, if you're not going to do it yourself, certainly you want to engage an attorney or a consultant of some sort who has experience in this, who can go and look up the laws. Now, most non-law firm compliance consultants probably are going to tell you, sorry, I can't give you legal advice and I can't interpret the law and let you know how it applies to you. But certainly at a minimum, you want to look at the state law and try to figure it out. If not, you can give us a call and we'll certainly help you with that. So something else I wanted to talk about are solicitor-only RAA firms. So believe it or not, there are actually firms out there that all they do is focus exclusively on making referrals and facilitating introductions to financial advisors. So individuals that will solicit on behalf of an RAA firm will often go ahead and get qualified as an individual IAR. Sometimes it's through, to kind of make things simple, they'll just become an IAR of the firm they're soliciting for. Other times they'll just set up their own investment advisory firm. Even though you set up your own RAA solely to act as a solicitor for a third-party investment advisory firm, you still are going to be subject to compliance requirements. And the specific requirements will vary by state, but most often include the formal establishment of a compliance program, including the adoption of written policies and procedures manual, maintaining proper books and records, as well as certain files related to advertising and correspondence. You still have your books and records requirement. And then you're going to have to keep track of all the disclosure documents and agreements that will need to be maintained. And of course, you're still going to have Form ADV and still be subject to Form ADV annual amendments. So being a solicitor-only RAA firm, while it does narrow your business model and it does limit the compliance activities you'll be engaging in, you're still going to have these very basic compliance requirements in place. You're still going to have a compliance culture and program. You're still going to have a compliance manual. You're still going to do all your filings and still keep up with books and records. So it's important to keep in mind that if you should work with one of these solicitor-only RAA firms or consider launching your own solicitor-only RAA firm, keeping in mind there's still going to be that overhead cost of maintaining compliance program and meeting the compliance requirements. Now, you can still have informal referral relationships. These aren't going to be subject to regulatory oversight. So when I say informal relationship, I mean there's two parties exchanging referrals. without a particular formal arrangement or without payment of a fee. It's just a relationship based on trust and where you each feel comfortable introducing the other to prospective clients. So you don't have to worry about registering as an IR. You don't have to worry about registering with an advisory firm, because if you're going to be an investment advisor representative, that means you have to be associated with an advisory firm. And this actually gives you an opportunity to engage with centers of influence that can really send you quality prospective clients. So we're talking about insurance brokers, divorce attorneys, mortgage brokers, real estate agents, personal finance writers or bloggers, business coaches, life coaches, private equity firm professionals, private bankers, and the list goes on. Consider if you have a niche practice, so for example, if you are working with retirement age clients, maybe you have relationships with estate planning attorneys, elder law attorneys, with someone who specializes in ERISA and Medicare benefits. Just considering the different providers your clients will have, and those will be great centers of influence. If you're working with younger folks, millennials, young professionals, that's where the mortgage brokers are useful, the real estate agents, the insurance brokers, people who specialize in student loans, whether it's consolidation or whatever, people who are working with doctors, OBGYNs, young professionals considering starting families. Really what this is it's about creating a network of professionals that service your client type and who can then refer these potential clients to you. So you can have the formal solicitor's agreement and solicitor's relationship where you're paying someone to solicit potential clients, or if you're more comfortable and kind of don't see or don't think that it's worth having the regulatory oversight for that kind of relationship, then really creating these informal referral relationships keeps you outside of regulatory oversight. You don't have to worry about all the different state laws, possible registration, and then you're creating a network of referrals that will benefit your clients but will also benefit your business by engaging these professionals who can service your clients and send you clients as well. So consider that as well if you're interested in bringing on more prospective clients but are worried about having a formal solicitor's agreement arrangement. So this year the SEC actually put out a risk alert discussing solicitors and the arrangements and different deficiencies they saw when performing routine examinations. So it looks like I have a question. Okay, Dave, go ahead.
Back on those professional relationships,
sure.
Are there any restrictions on what would you call them, like referral fees that you could pay to them, give them a gift card, give them a gift, anything that we should be aware of about what's allowed or not allowed in that environment?
Sure. So for the informal relationships, you're not going to be paying them a solicitor's fee. So you wouldn't for every relationship they send you, you wouldn't be paying them because that would trigger the solicitor's rule. Okay. However, you know, it would be perfectly kosher to send them a gift, say at the end of the year, and just say, you know, thank you for being a trusted, you know, partner or,
Right.
you know, resource for my clients or whatever. You know, that would kind of fall into the whole gifts policies and procedures you have in place. You know,
Okay.
giving something small that's a token of your appreciation, but again, making sure it's not a gift that's so expensive or so luxurious, etc., that it's going to somehow sway their opinion on you.
And that kind of goes into the $100, $200, you know, rule of thumb type of thing. Just keep it simple, and it can't be tied directly to something. It just has to be a token of appreciation generally.
Yeah. I mean, it could be a token of appreciation. I mean, and other things you can do besides just directly, you know, referring clients to them. You know, there are other things you could do in order to support one another. So if you were to do, say, a joint seminar, a lunch and learn, for example, say you brought a mortgage broker and you invited a bunch of young professionals interested in buying their first home, you know, you could, as WT Wealth Management, could sponsor that lunch and learn. You could pay for the lunch and learn. And that would be a good opportunity to give something of benefit to your referral source that wouldn't trigger any of these regulatory issues.
Gotcha. Okay.
So there are, I mean, there's certainly ways you can still benefit them indirectly
you can refer
by doing something like that.
And you can refer people back to them. It can be mutually. A mutual referral relationship, that kind of thing. So, okay, great, thanks.
Yep, sure. So going back to the deficiencies, so the SEC noted there was a failure to provide solicitor disclosure documents. That was the first deficiency they found. So failure to provide these to prospective clients. They noted that there were frequent instances where the solicitor disclosure documents were delivered, but the disclosures themselves were inadequate and did not contain all the information required by the solicitor rule that I went over earlier. The risk alert specifically referenced solicitor disclosures that describe the solicitor's compensation using vague or hypothetical terms, which were deemed deficient, as opposed to using specific terms describing the actual compensation paid to the solicitor. And that includes if the solicitor is splitting the fee with the advisory firm, or if it's based on a certain percentage of fees that the advisory firm receives. These disclosures need to be very specific as to what the solicitor is actually being paid, where is it coming from, and if there's any additional fee the client is paying that they wouldn't otherwise have paid for if they didn't come through the solicitor. So again, the solicitor disclosure documents being inadequate was the first deficiency the SEC noted. The second one deals with client acknowledgments. So the SEC found advisors failed to receive completed client acknowledgments in a timely manner. And they also noticed some advisors received these acknowledgments without dates, so you couldn't prove that it was before or at the time the client signed, or they were dated after the client had already entered into an advisory agreement with the advisor. So again, violating that rule of the client receiving all of this information before or at the time they become clients of the advisory firm. The third deficiency dealt with solicitation agreements themselves. The SEC observed that advisors paid a cash fee to a solicitor without a solicitation agreement in place, or paid a cash fee to a solicitor pursuant to a solicitation agreement that fail to include the required contractual provisions. Now, the contractual provisions that are required to be in the solicitation agreement are the following. A clause describing the solicitation activities to be performed and the compensation to be received. A clause obligating the solicitor to perform its duties in a manner that is consistent with the advisor's instructions and the provisions of the Advisors Act. And a clause requiring the solicitor to deliver the advisor's disclosure brochure and the solicitor's disclosure document at the time of the solicitation. One other deficiency the SEC noted were related to the bona fide effort for an advisor to ensure that their solicitor is actually complying with these requirements. So they noted that advisors failed to make that bona fide effort, and further noted that advisors did not have a reasonable basis to believe their solicitors were complying. So you can't just have all these documents in place. You have to make sure that your solicitor is actually complying with all these requirements, actually providing a copy of the disclosures. So how you would ensure that they're complying is really up to your firm. Again, you should have policies and procedures in place to ensure that your solicitor is complying. So whether that's as simple as them CCing you or your designee on an email to a potential client with everything attached. You know, the acknowledgement, yes, you have your client acknowledge, you know, they received the disclosure, your Form ADV. Some states actually require that you provide a copy of the actual solicitor's agreement to the potential client. The acknowledgement is not going to be enough in this case where you're trying to determine if your solicitor is actually complying. So it could be that, you know, you require that they forward you emails where they sent the documents to the client. That you require some sort of audit. You know, the CCing with the emails is the simplest way. Or if there's some sort of CRM that's being used or some sort of other technology platform, getting a report of when these documents were sent to these potential clients, that would be useful. And finally, the SEC referenced advisors with similar conflicts that could implicate violations of other provisions of the Advisors Act, such as a breach of the advisor's fiduciary duties. So, for example, if an advisor recommended service providers in exchange for client referrals but didn't disclose those conflicts of interest. So you're going to have the requirements on the solicitor side, but we're keeping in mind that you have your own Form ADV, and you're going to have to disclose that you have a solicitor, all the conflicts of interest related to having that solicitor, and what happens if you're recommending certain service providers because of that relationship. I mean, it is part of your fiduciary duty to be clear about any conflicts of interest. It's your requirement through your Form ADV disclosures that you discuss all material conflicts of interest. And then also, you know, not just the disclosures in Form ADV, you know, you could be violating books and records requirements if you don't keep copies of these solicitors' agreements. If you don't keep copies of your efforts in ascertaining solicitor compliance. So just keeping in mind, you have your requirements in terms of solicitors, and then you have the related requirements where you could potentially be, you know, violating other rules by not meeting your obligations with these different document requirements. So I hope this has been helpful in terms of how the solicitor works for your business, the different requirements for having a solicitor, where you need to look to for guidance in terms of state requirements potentially being triggered, whether you need your solicitor to be registered or not, how they can be compensated, who they would need to be registered with, and what relationship would trigger the registration. So, we talked about SEC versus state. And then also these common deficiencies. Obviously, the SEC is releasing risk alerts because these are common deficiencies, and they want to notify advisors of the issues they're seeing so that they can fix them. So knowing these common deficiencies, making sure that you have in place the policies and procedures, the appropriate clauses in your contracts, that you're following the rule to ensure that you're not violating the Advisors Act. And really just will make your life simpler because, again, this is low-hanging fruit for examiners who are coming in. And as I tell all my clients, all these regulators, they're trying to do more examinations more frequently, so don't make it easy for them. The rules are simple enough. You just have to follow them and keep on track. So that's the end of today's presentation. If you have any questions, you just have to dial *6 to raise your hand. Do I have any more questions on solicitors? Solicitors agreements, state SEC requirements. Alrighty. Well, if you do come up with any questions later on, by all means, you can email compliance@myrialawyer.com, and a member of our compliance team will respond. You can email me directly if you'd like, Leila, L-E-I-L-A, @myrialawyer.com. And, of course, you can always call us and schedule a call to discuss further, 770-462-2118. So thank you, everyone, so much. I have enjoyed doing this boot camp with you guys. I hope you have enjoyed it and found it informative. If you feel so compelled to do so, and I hope you do, we would greatly appreciate a review on Google about the Compliance Boot Camp as we're trying to convince other advisors that it's a great source of information and really will give them the education they need about how to run their own compliance programs in their business. So I am going to stop the recording, and everyone have a great day.